Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group. We're located in the always beautiful and sunny Scottsdale, Arizona. And today we're talking about Ghislaine Maxwell. Guilty verdict, 5 of 6 counts. Ghislaine Maxwell, the jurors came back today. We were bracing for a lot more deliberation. And so they came back and rendered a verdict on 5 out of 6 counts, and it's guilty. And so the headlines are flying all over the place. You know exactly what the outcome is, but how did it happen? That's what we've got to talk about. And so let's just jump right into it, shall we? You know where to ask the questions. You know where to find the clips. Let's get to the verdict. It started off today, as usual, with Inner City Press reporting. He said late today, after a lot of deliberation, after a lot of waiting, he reports a verdict has been reached in the U.S. versus Maxwell case. Please be advised that a verdict has been reached in the above matter. The verdict will be announced in open court shortly. So Inner City Press is wandering around New York City, and he hears that over the buzzer. Verdict has been announced. They get back to the monitors. They hear Judge Nathan says, as the defense attorneys and prosecutors and everybody piles into the courtroom, says, Judge Nathan, I'm going to read the verdict after the jury comes in. And anyone in the courtroom who makes a noise will be removed. Bring in the jury. So it happened. This is the scene. You can see here many people are masked up, Omicron variant, spreading around New York like wildfire. Judge has been on ultra high precautions, even going so far as to suggest that maybe there may be a mistrial due to the variant. Not going to happen. Obviously, we have a verdict, but this is what the jury looked like today. You can see at this table, these are the prosecutors. At the defense table, you see some other people there who are present. Inner City Press reports courtroom 318 has Leah Safian, who is interestingly inside the courtroom. This is an attorney who's not really registered, my understanding, in New York, and she's been giving very interesting access. But she is there, sort of a family friend attorney, and joined by her family, sisters Isabel, Christine. We have Kevin Maxwell, who has been there many, many times. We've seen Isabel and Kevin working their way to the court multiple days during this proceeding. And so the scene is set. The jurors are there. They're impaneled. They've reached a verdict. Maxwell's defense team, along with their family, are waiting. Prosecutors are waiting with bated breath. Judge Nathan says, as the jury enters, have you reached your verdict, ladies and gentlemen of the jury? Foreperson stands up and says, Your Honor, we have. So the court clerk hands over the envelope over to the prosecutor, over to the court clerk, hands it over to the judge. The judge picks it up, opens up the envelope and says, in the case of United States of America versus Ghislaine Maxwell, as to count 1, guilty. And Ghislaine Maxwell just feels it. You can see it in her face. As to count 2, not guilty. And the defense team has a little bit of relief in the moment. But then Judge Nathan continues and opens up out of the envelope. As to count 3, guilty. And then, folks, after that, it's just a cascade. Count 4, guilty. Count 5, guilty. And count 6, as to Ghislaine Maxwell, guilty. Ladies and gentlemen of the jury, I'd like to thank you for your service. You've been instrumental here in the execution of justice. Please see the bailiff for the final paperwork on your way out. Have a very safe and happy new year. Jurors exit out of the courtroom. And we see some jury verdict forms that are going to look like this. Of course, these came from the jury instructions that were distributed previously. And this is not what the final verdict is, but you can see as to count one, they're going to check this box, guilty. A conspiracy to entice individuals under the age of 17 to travel in interstate commerce with intent to engage in illegal activity. As to count two, Jane only. Remember that one? Got a lot of questions about Jane. Count two was enticement of an individual under the age of 17 to travel with intent to engage. That one, of course, is a not guilty. And the rest are guilty. We can see that we're going to see these here soon enough. Probably tomorrow these will come out. These will be signed off on by, I think it's Juror 48, who's the foreperson. And so he or she will sign off on that tomorrow. But count three, conspiracy to transport individuals under the age of 17 to travel. That one is a guilty. Count four, transportation of an individual under the age of 17, Jane only, guilty. Count five, conspiracy to commit trafficking of individuals under the age of 18, guilty. And then count six, trafficking of an individual under the age of 18, Carolyn only, guilty. And so that's what the final verdict is going to look like. And you can imagine that the consequences could be somewhat severe. And so I don't think I posted the poll form, but I just updated the poll form. I know the show was sort of set up for another day of deliberation, which we did not get. But I think we have the poll form for the sentencing, if you want to opine on that. The mind map and the poll form are now in the chat. Let me pin those up there so we can ask a couple of questions. Let's take a look at those questions before we continue our coverage, because there is still a lot more to talk about. But let's see what the questions might be bringing to us here. We have the Maxwell sentence. Okay, so some opining on the sentence. Here we see this. The Maxwell sentence, is it anywhere between 0 to 5, 5 to 10, 10 to 20, or 20 plus? What do you think it should be? What do you think it's going to be? People are throwing it up in there in the range. Now, right, you know, we're certainly going to see what this looks like. And so you can answer this any which way you want, whether you think this is what she should get or whether you think this is what she will get. But it's looking like people are looking at the 20 plus, hoping for a big, big sentence. We'll see. Also threw this in here. We're not here quite yet, so we're going to talk a little bit more about some of these issues. But what might the biggest appealable issues be for Ghislaine Maxwell? Now, obviously, they've been setting up an appeal for a long time. They have been filing motions left and right, sort of presuming that they're going to lose and then be filing appeals. And so I just threw some of these in here. Something else is being the appealable issue. I'll be curious to see what people have to say about that. But we'll review some of this stuff here today, but we'll just throw that out there. Will others be prosecuted? We have 75% saying no. Of course not. Probably a pretty obvious answer on that one. And then let's see, are you happy with this outcome? So we've got 49%, almost half saying yes, 20% saying no, 30% still saying undecided, which is a fair answer at this point because there is, she hasn't been sentenced yet. If she gets a slap on the wrist in probation or something, right, then you're probably going to be unhappy about it. But if she gets 35 years, maybe you're happy with that one. And so you can see how that decision might change as well. And so keep those responses coming in. We'll check back in periodically as we go throughout the remainder of the coverage today. Get some feedback from everybody. Now, of course, there were some amazing people covering this case. We've been following Inner City Press aggressively. He's been doing an amazing job, and he's over at Substack. He's on Twitter. He's got a Patreon. He's got it all over the place. So make sure you're following him. But we also were following Adam Klasfeld doing the same thing. And so he was also posting this, and he's also reporting same verdict here. Big shout out to Adam Klasfeld for his reporting on this. He's really invested a ton of time getting this thing out to fruition. Same here with Joe Neerman. He was there, brought his mask, and saying, lock her up, lock her up, lock her up. And so there's a lot of reaction going on around there. Now, I did also Want to give a shout out to Addy Ads. I just literally watched a video, a couple videos that he posted. Didn't have time to clip them for today's show, but Addy Ads is out there, and he had a video of the reaction around the courthouse, and there didn't seem that that interested. In other words, what happened outside of the Kim Potter courthouse was a lot more colorful in terms of activity. People were very, very, loud and boisterous and cheering. I didn't see much of that outside of the Thurgood Marshall courthouse out there in New York. And so, doesn't mean anything, but it was just an interesting thing to see. So also shout outs to Addy Ads. Now, a couple interesting things here that we can dive into. Now that this has happened, of course, we're going to come back for sentencing, and we're going to start to see some more of these jury questions. They had a ton of questions today. But there's something interesting that happened today that I wanted to just put a pause in. And so remember, I think not yesterday on the show, because yesterday we talked about Burlington, the Burlington Coat Factory, wild case that is getting a lot more attention now. But if you missed that, you can check that out yesterday. But on Monday, we talked about Ghislaine Maxwell. And on Monday, remember what we spoke about? We said that the jurors were wanting highlighters. And they wanted notepads, and they wanted copies, and they wanted color sticky notes, and they were going to be mixing and matching, and they were going to be mind mapping this stuff all over the place. They had 83 pages of jury instructions. They had no real urgency to come to a decision. We had some people who were thinking this thing through. They needed office supplies. And the judge said, all right, get it to them. Go get them. And so they did. They started gathering these office supplies. And so you and I and the rest of us out here in the community, we were just sitting around expecting this to take a while. What do you need highlighters for? If not to highlight the heck out of everything. And then suddenly we got a verdict today. Very weird. Weird how that happened. And I made this bar chart before the verdict came out today because I was interested in observing the timeline here. You can see on this bar chart, we got a verdict today. And so the government, when they presented their case, they took about 8 days. Now, really, that's being generous to them. They really took about 7.5 days because one of those days was a sick day, if you remember that. So we can kind of get that out of there. But let's say, okay, you give them 8 days. Same thing with the defense. They had like 1.5 days or, kind of 2 days in their case. And then the jury was taking this was really about 5.5 days. They had a half day in there. I think it was for something else happened. I forget what it was. So I was going to see if the jurors actually took more time than the government to present their case. Turns out they didn't. It's about 2 days shy of it. But it was curious because it felt like they were going to keep this thing going. Now, we didn't talk about the Ghislaine Maxwell case yesterday, but at the conclusion of the conversation yesterday, it didn't seem like we were getting close to an outcome. Right? Because this was what the Daily News was reporting. They said that yesterday, COVID cases could bring a mistrial in the Ghislaine Maxwell case because this variant is spreading through New York. There are people standing outside that, trying to get testing and things like that. Judge warns. And the jury said yesterday that they were at a good point towards a verdict. And so, when I sort of saw this, I was thinking, I don't know what that means. A good point to me doesn't really mean that you're close. I guess maybe at a turning point. I don't know. But the judge warned about it yesterday. She said we're seeing an astronomical spike in the number of COVID positive cases in New York City. And she sort of warned jurors a little bit. They came out with a note yesterday. So yesterday, let's rewind the clock. Yesterday, 5 p.m., it says our deliberations are moving along and we are making progress. We are at a good point. We would like to end today at 5 p.m. and continue tomorrow at 5 a.m. So yesterday, the jurors are like, yeah, we're moving along. We're at a good point, but it doesn't sound like they're really close. At least that's how I was reading it. It didn't seem to me like it was imminent. And so then the judge came out, and this is where I think the defense might sort of, latch onto this. The judge came out and told the government and defense lawyers yesterday, at the closing of yesterday, that she was preparing to order jurors to continue deliberating through the weekend until they reach a decision, right? So now you've got, if they don't have a decision soon, they've got Thursday, they've got Friday, New Year's Eve, they've got Saturday, New Year's Day. They're going to come back Friday, Saturday, Sunday if they have to. The judge is preparing to tell them that. Why? Judge says, well, very simply, we're in a vastly different place regarding the pandemic than we were only a week ago. We now face a highly and daily escalating risk that jurors and necessary trial participants would need to quarantine and disrupt the trial, putting at risk our ability to complete this trial. So I conclude proceeding this way is the best chance to give both the jury as much time as they need and avoid a mistrial as a result of the variant. Okay, so the variant is now coming into this thing. And so the judge is sort of, hurrying this along. And the defense is going to say, well, that was inappropriate. You hurried it along. You came out and told the jurors that they were going to have to be there on their holiday. And they didn't want to do that. So they just went in there and said, all right, who's holding out? You're saying not guilty? Why, moron? What, are you dumb? And then it's 5 or 6 people. Yeah, you are dumb because blah, blah, blah. And he says, fine, let's just get this over with. And so he flips or she flips, and then you get a verdict. Nathan said that she's not going to force the jurors to come in if they had unmovable commitments, but she did ask them to continue to wear masks at all time. She says, I'm going to ask that deliberations continue forward on schedule every day this week until a verdict is reached. So please make yourselves available should it be necessary to sit for deliberations for the remainder of the week. And she says, of course, by this, I don't mean to pressure you in any way. You should take all that time you need. Have a good night. Stay safe and healthy. So she tells him that. I don't mean to pressure you in any way, but guess what? They came out. That's the defense argument. Bobby Sternheim's going to come out and say, yeah, judge, as soon as you said that, as soon as you threatened to keep them over the holiday break, they came out with the verdict very conveniently. Yeah, isn't that interesting how that works? So we'll see how that happens. Now, I had a bunch of stuff to talk about today until the verdict came out and sort of changed everything, but there still are a couple things that are worth discussing. So a couple of these appealable issues now that I want that we can still touch on. So we just talked about the first one, the idea that maybe the judge or the process was being hurried along too much a little bit. And that's a violation of due process, right? If your son or daughter is getting a trial and you have a bunch of jurors deliberating and contemplating over the evidence, you kind of want to make sure that they do a good job at that your son or your daughter gets a fair shake when they're going through the system. And so if a prosecutor came out or a judge came out and said, Mrs. your son or daughter, we're going to have to hurry this along. And your perspective, your argument is, well, I'd like them to look at everything in detail because this might result in my son or daughter going away to prison for 30 years. But the judge doesn't do that. The judge just pushes it and pushes it and pushes it. And so as a human people, right, you buckle to these pressures and people succumb to peer pressure all the time. And what happens in that situation if somebody who was a hard no now has the mob of other jurors around them bearing down upon them to make a decision? You have to change. Well, that's just the nature of jury deliberation, isn't it? Sure, but it's also something that the defense is going to latch onto, and you can expect that. So we saw that. The other issue that I think is interesting is yesterday, there's a little bit of a conflict over these jury instructions. And so yesterday, Everdell, Maxwell's defense lawyer, filed a motion that got docketed yesterday. He actually filed it the day before. It hit the docket on 12/28. You can see he was upset about one of these jury instructions. And so the jury just came back, obviously, and they just rendered a verdict. And Maxwell's defense team is not going to be happy about this verdict. But guess what? Before they rendered the verdict, they complained about the instructions. You remember how this all happened? Do you remember that every time the jurors came out and they had a jury question, that there was that one incident where Maxwell's team, they left the courtroom and they came back in and they said, you know what, we want a copy of that. We want a copy of that note there, Judge. And the judge said, ugh, all right, well, we got to redact it because it's got the name on it. And so we're going to go through the whole formal process. And they did. And they gave the Maxwell defense team a copy of that note. Well, one of those notes, it could have been that note or another note, doesn't matter. They didn't like the question that the jurors gave to them. And so what are they going to do to try to appeal this? They're going to say, well, not only were the jurors rushed and hurried along in this process, but they also had a bad set of instructions. Of course, they came to a guilty verdict, Judge. Obviously, they would. They were following the different guidelines. If they would have had the right instructions, they would have baked the right cake. They wouldn't have made it so disgusting and falling apart, but they didn't. And because we objected to this, Your Honor, because we made a complaint about this, the jurors hinted that they were going askew, that they were interpreting these rules problematically, and we tried to correct it, Your Honor. We filed a motion on 12/27, 2 days before the verdict came out, asking for your help in correcting this. You didn't do it. And that's an appealable issue. No wonder she got found guilty, because you issued wrong instructions. And so that's what he filed back on 12/28. And of course, this type of stuff is not done because he's expecting to win it on this at this moment. This is all done to build a record so that he's got something that he can appeal later on in the future. He can't come back. Maxwell's team can't come back and expect a judge to do something about a problem that they didn't raise when it happened. It's sort of that concept, right? Well, you didn't complain about it when it happened, therefore there's nothing I can do to fix it. You object, you make a record of this, and then you deal with it. And so this is what he filed 2 days ago before this verdict came out. And so we'll just take a quick look at this, and then we'll take a look at the mind map, and we'll sort of play around and explore that non-prosecution agreement. And then I imagine we'll take the rest of the hour or so for questions. But you can see here that we've got Judge Nathan is the person who's being addressed. Christian Everdell sends this in, and he's saying, listen, Judge, we got a question from a jury. We respectfully submit this question. We need to give the jury additional instruction to correct the apparent errors in their understanding of counts 2 and counts 4. Recall, though, count 2 was a not guilty. So we don't really care about that count. But as to count 4, yeah, he's going to say that this argument applies to that one. And so here's what he's concerned about. The jury's note this afternoon came in. It's Court Exhibit 15. This is what the jurors asked. And remember, Maxwell's guilty on count 4. Under count 4, if the defendant aided in the transportation of Jane's return flight, jurors are asking, so in other words, if Maxwell helped Jane return, but not the flight to New Mexico, where if the intent was for Jane to engage in activity, can she be found guilty under the second element? Okay, that's a really complicated legal question. A lot of stuff that you can fight over about that. Under count 4, if Maxwell aided in the transportation of Jane's return flight, but not the flight to New Mexico, where if the intent was for Jane to engage in activity, can she be found guilty under the second element? So it's like not even a good question, right? What are they even asking? I don't even really know. It's a convoluted question. Where / if the intent was for Jane, can she be found guilty? So they're being very specific here. And so the court responded and says, the court, or count 4 alleges, if you actually take the count, it says arranged for Jane to be transported from Florida to New York on multiple occasions where this would happen. So the court just responded and referred the jury back to instruction number 21 of the jury charge. So this is where the judge just sent them right back here and said, well, we're not going to answer that. Just go look at instruction number 21. Well, if you go back to instruction number 21, then it says something about being transported from Florida to New York. But what did they talk about? They asked about, it sounds like, New Mexico. Jury's note this afternoon. So they're asking about New Mexico, but the indictment or the count in count 4 says from Florida to New York. They're asking about New Mexico. So you see here, he's saying there's a problem here, Judge. Why are they talking about this? And so here's his argument, right? He's making an argument. Judge, you should have done something on this. You should have issued a curative instruction. You should have corrected the jurors. They're misinterpreting this. They're asking about flights and second elements in New York and Florida, and the indictment doesn't match the jury instructions, and the jurors are confused. And we're concerned that because they're so confused, they're going to find her guilty. And so I'm asking, Judge, for you to resolve this. So he did. He says, listen, Judge, without further instructions, the jury could convict Maxwell based on a constructive amendment or on a prejudicial variance from the indictment. He's saying that the ultimate outcome, the final conclusion of all of this, is Maxwell is now, the jurors are now altering the indictment. They're making this constructive amendment, a constructive amendment being something that is not a formal amendment, right? You can have a formal documented, this is an amendment, this is an addendum to a contract, but you can also have sort of a constructive amendment where we just kind of just do. I know the contract says that. It says I'm supposed to pay you on the 15th. It doesn't work for me. It doesn't work for you. How about I just pay you on the 20th, right? Are you good with that? All right, so we're just going to sort of amend it, but we're not going to go back and formally amend the document. So here he's saying that because the judge gave the jury the wrong instructions, it's a constructive amendment. It's modifying the underlying indictment in a way that's not permissible. It's changing it. And the jurors are hinting that they're interpreting this in a problematic way based on the question. We can peer into their minds based on what they're asking. He says the court have recently explained the law, and so he gives us some guidance, right? If you want to prove this, you got to show all this stuff. He says the second court has given us some more guidance on this, and he also talks about a variance. It occurs when the charging terms of the indictment are left unaltered, but evidence at trial proves facts materially different, in contrast to a constructive amendment. He says here, Court Exhibit 15 indicates the jury is considering a conviction on the substantive, and they did. They actually convicted her on this, on a substantive transportation offense charged in count 4, based on Jane's alleged travel to and from New Mexico and activity that took place while she was there. He says that is not what the indictment alleges. Count 4 alleges that Maxwell arranged for Jane to be transported from Florida to New York. That's it. He says, as such, a conviction on count 4 must be based on evidence that Maxwell intended Jane to travel from Florida to New York, and while in New York, violate the law in New York. And so the government has represented, they say, to the court on numerous occasions that Maxwell cannot be convicted on any of the 4 Mann Act counts, including count 4, without proof of an intent to violate New York law. That excludes any conduct, they say, that would have occurred in New Mexico. So the jurors are asking about New Mexico. He's saying, you can't do that. So he goes back and he actually clips out from the government's testimony, I think is what he's clipping. He says, the only illegal activity identified in the entirety of the jury charge is a statute in New York. There cannot be any risk of confusion on that score. This particular charge reminds the jury of that and includes that language as well. The jury has not been charged about any laws in New Mexico, so there can't be any risk of confusion for exactly that reason. So do you see what he's doing here? He's going back and he's saying, Judge, there's a lot of potential for confusion here. You've got Palm Beach, Florida, you've got New York, you've got New Mexico, you've got Little St. James, you've got a whole bunch of complex things happening here. And the jury just came back out in Court Exhibit 15 in one of the jury notes. They asked about this. They're conflating the issues. They're making the indictment read a way that it doesn't. They're saying that any of this activity that might involve New Mexico might be enough to be considered under count 4. But they're saying we can't do that. And in fact, we've had a conversation about this, Judge. We talked about this previously. Here is an excerpt from trial transcript 3140-1016. We said specifically there can't be any risk of confusion for exactly that reason. And there is confusion about this, hence the jury question. So it says now, Christian Everdell, and I think this is an appealable issue. We'll see if it goes anywhere. Despite the government's confidence about these instructions, Everdell says that the note indicates the jury is considering a conviction. Jane's alleged travel is that the core of the criminality happened in New York, a conviction based on Jane's travel to and from New Mexico, and any activity that allegedly occurred there would be premised on the facts elicited at trial that are completely distinct from allegations in the indictment. Okay, so look, and this is a very important point, and this is something that I think gets missed a lot of the time in legal analysis for criminal law. The indictment is the game plan. That's it. You don't get to say, well, you know, it was kind of trafficking, but not really. And so we're going to get somebody with like attempted trafficking. Or here's a better example. Somebody saying, this actually came up in this case. The idea being that Ghislaine Maxwell maybe didn't commit offenses against a minor. Remember, we were talking about 2 of these victims, and some of them were actually over the age of consent. And so you couldn't consider any activity that took place in those locations to be involving a minor. And so the response to that was, well, fine, just charge her as an adult. charge Ghislaine Maxwell if those individuals were actually over the age of consent. Okay, you can't get her as a minor, as trafficking minors, but how about trafficking adults, or how about how about prostitution? Charge her with something else. True. Yeah, fine. Go ahead and do that. But that's not in the indictment. That's not what they charged her with. This trial is about what they charged her with. And so if it's going to be a little bit different, if it's going to be a little bit distinct, that's not how this works. You don't get to say, oh, well, in that case, we thought she was a minor. Turns out she's not a minor. So we're just going to go ahead and amend all of this stuff and then charge her with a different statute because we screwed up during the charging process. Don't get to do that. And so here he's saying that's what's happening. The original underlying indictment is being modified. It's being changed. It's evolving as the case goes by. As the jury instructions landed on the desks of the jurors, it is different. And so he says, listen, Judge, if this court does not instruct the jury that they cannot convict Miss Maxwell on count 4 based on the alleged events in New Mexico, it's going to permit the jury to convict Miss Maxwell of an offense other than that was charged in the indictment. And it's going to constitute a constructive amendment. And a constructive amendment like this is per se reversible error without a showing of prejudice. You see what that is there? And he's citing, guess what case he's citing? Watch this, folks. Watch this. Second Circuit case from 1998. Oh, yeah, because that's the district that he's in. That's the circuit that he's in. And guess who's going up to that Second Circuit court? Oh, yeah, Judge Allison Nathan, the judge from the Ghislaine Maxwell trial. So he's going to appeal it, and he's telling them, hey, Judge, listen, a constructive amendment like this is per se reversible error without a showing of prejudice. Now, the judge ultimately didn't care. The judge denied this. We're going to see this, but here's the further of the argument. It says, at the very least, if the jury convicts Maxwell on count 4 based on Jane's alleged activity in New Mexico, it would be a substantial variance from the allegations in the indictment. In the indictment, it requires an intent that Jane traveled to New York and violate New York law. And he says, so therefore, the court should instruct the jury, as requested below, to prevent a variance from occurring. The judge should have told him this, is what he's saying. He says, Maxwell has no burden to prove prejudice at this point, since the variance can still be prevented by a curative instruction. So, Judge, we're alerting you of this problem. They're going to come out here and they might convict her on count 4, which they did. And I'm warning you, this could be a problem. But at this point, because we didn't have a verdict when he wrote this, you can fix it. Not anymore. Moreover, because the same issue arises with respect to the substantive enticement offenses charged in count 2, the court must give the same instruction as to count 2 as well. We also see that he wants a supplemental jury instruction. So he's saying that in order to correct this error, you should give them another note. Look at all this case law. Second Circuit, 2001, Second Circuit, 1960. We got Second Circuit, 2014. We have another Second Circuit, 1985. Right? And the older the case, it doesn't, don't think about those as all that meaningful, other just to sort of give you a smattering of the dates. It goes on. He says the jury note indicates the jury is confused about the second element of count 4, and by extension, the third element of count 2. Now, count 2 doesn't matter because she was not guilty on that one. But he goes through a little bit further, and he says that they need a curative instruction. So here's what he recommended, and this was a couple days ago. He said, for the reasons set forth above, we request the jury give the jury the follow additional instruction tomorrow. Okay, so in other words, that would have been, he submitted this on the 27th. That would have been yesterday, the 28th. He wanted to, there was an 83-page document. Everdell wanted to insert something else in there. And he wants to say, jurors, as to the third element of count 2, you must determine whether the government has proven beyond a reasonable doubt that Maxwell acted with intent that Jane would engage in activity within New York. Within New York. As to the second element, you must determine whether the government has proven beyond a reasonable doubt that Maxwell transported Jane with the intent that Jane would engage in activity within the state of New York in violation of the law. An intent that Jane engage in activity in any other state other than New York cannot form the basis of these two elements as to count 2 and count 4. Okay, so you see how this is working? This is why it's very complicated. It's why it's such a tall order to ask, a group of 12 people to agree on anything, like lunch. Get a group of 12 people together and say, what do you like on your pizzas? Can we order one set of pizza for everybody? How would that go? Not well. It doesn't go well. So here you have the same concept now. All these complicated rules, all these different permutations. You've got different people reading things differently and a lot of pressure coming down to bear. And so they did this not because the judge was going to come out here and do anything about it, but because if and when, as happened today, they come out and find her guilty on that count 4, they now have an appealable issue. And throughout this entire trial, they've been doing this as to every one of these counts. And we've been watching this every turn of the page. So after that letter was filed yesterday, Judge Allison Nathan denied it, said, no, not going to happen. Klasfeld reported, said that this was filed in the wee hours of the night. And said, well, the jury actually didn't ask about this. Says, she also says that the defense's final proposed instruction is also, quote, just wrong. Jurors can consider conduct outside New York and deciding conduct in New York, she says. Right? So she's sort of interpreting it differently. Now, if she's wrong about that, that's reversible error. Okay, that's exactly why he filed that motion to say, well, I'm going to argue that it's other than that they can't consider conduct outside of New York. She says, sure they can, including all the stuff in New Mexico. So it's not a problem about that. Now, again, you can see that inner city press, we're sort of watching this theme happen about these other things that might be problematic or might be appealable. Judge Nathan sort of had this little reversal happening here. Back on December 28th, this was yesterday, she was talking about deliberations going up, speed up or pausing them. What do they want to do? She says about Omicron, she left the courtroom to make a decision. Now, inner city press noted this. When the jurors said that they were having some issues, she told jurors previously that they were going to be off this Thursday and this Friday. But now she's saying they're going to be deliberating December 31st and January 1st. What happened about that? So is that actually true, right? I mean, I'm sure it is. Inner city press is there. He's watching this. But if it is the case that Judge Nathan went out there and said, okay, jurors, you're getting 2 days off, Thursday and Friday. Have a nice New Year's. Omicron came. Now I'm scared. Now we're going to have to flip this. You're going to be here Thursday, Friday, in fact, Saturday and Sunday, if need be. But the judge already said one thing one way. And if she said something one way, and then you have a bunch of jurors that say, oh, great, we're going to have Thursday and Friday off, and we're going to start making plans, and then they do that, and then they start, scheduling things, and then the judge comes back and says, no, you have to decide now. Saturday and Sunday, I don't care what it takes. New Year's party, cancel it. You're going to ring in 2022 in New York City, in the Thurgood Marshall Courthouse over here. And so what does that do to the jurors? Do they just flip their position and go, well, I had that barbecue. My wife is going to kill me. If we're not there on New Year's Day, I'm a dead man. So wrap it up. What'd you say? Not guilty? Not anymore, buddy boy. Flip your verdict on that. So he's noticing, is that an appealable issue? We don't know. And so Judge Nathan sort of, as this went on, was saying, well, I'm just going to tell them every day this week, which of course is a change. It's not Thursday and Friday going off. We had some other conversations take place. And before the jurors came to their conclusions, this is a weird thing because they wanted a bunch of transcripts even today. Remember this? Today, this is how this started. 5 hours ago, Klasfeld reported that they wanted a whole series of additional transcripts. They wanted Shawn. This was Carolyn's boyfriend. They wanted Espinoza. This was Epstein's ex-assistant at the Epstein & Co. company. They wanted these two defense witnesses who were both FBI agents. Today. And they also wanted the testimony of Elizabeth Loftus, the expert witness. Today, they wanted that. They clarified this. We are requesting the transcript of expert witness on memory. And so we're all just sitting around here, right? You can see here, this is 5 hours ago. And we're all just going, man, they're getting a lot of these transcripts, and now they're having disputes about this. There's a dispute about redacting the testimony of Simberly Espinoza. We already heard from her. We've got Loftus. All that took place earlier this morning. It goes to 2:12, and now, okay, we still have the same conversation. So now at 2 p.m. this afternoon, Inner City Press is reporting that Bobby Sternheim says we got another note at the jury table. And so at this point in this trial, the jurors know full well that the judge is like urging them to get this case resolved. You're going to be here all week, throughout all week. That means Thursday and Friday. I know I told you no. I know it's New Year's Eve, but we're going to be here. And so they still ask for more transcripts. They come back and they say, may we please have the Larry Visosky testimony here? And there's laughter in the courtroom. People are going, what the heck is going on with these jurors? And the laughter is sort of like, well, sure, I guess not. Do they want them? Should we just print all of them? Do they want the transcripts from everybody? Just get them all and cart them in there. People are sort of like, are you okay? I guess they're going to be deliberating through New Year's. People are laughing about this because they just keep going down the list and they want more and more transcripts. And Klasfeld is reporting the same thing. He's saying, hey, they're scrutinizing the testimony of both former Epstein pilots. And so we were, calculating this, and it's kind of a hilarious thing, but there were people on Twitter saying, how many people have asked for transcripts? You've got Katie Fang here says, I'm struggling with how many asks there have been for transcripts. And Klasfeld notes and says, yeah, there's been 13 of them. The prior 8 were all government witnesses, all 4 accusers. We had ex-Epstein pilot David Rogers, who was here, Juan Alessi, Matt testified, Greg Parkinson. And so Klasfeld says 24 witnesses in total. The defense called 9. So 13 out of 33 total witnesses. And these were earlier numbers in the day. And so I sort of went through this after they asked for Visosky. And I think these are up-to-date numbers. So the government presented 24 witnesses. You can see that here. The defense presented 9 witnesses here. I believe that's right. And so the jurors were asking for all of these transcripts. I mean, they were asking for basically 13 transcripts, 14 maybe with Visosky. And about 5 of those came from the defense and the other 8 came from the government. And so we were trying to sort of tease out what they were asking about. What were they thinking? What was going through through the jurors' heads? And this is kind of the breakdown of the transcripts that they were asking for. So they had Epstein's 2 co-pilots. We had David Rogers and we had Visosky here. They read those. They read Juan Alessi. We had the 4 victims, Kate, Caroline. We had Annie Farmer. We have Jane, the 4 victims. We have Parkinson, and then we have Shawn. Shawn was the boyfriend of Carolyn. And we also have Matt, who was the boyfriend of Jane, the soap opera actor. And so there was something interesting that stood out to me when you compare and contrast that with the defense witnesses. The defense witnesses, of course, they had a lot less of them. I think they called 9 is what we said. Yeah, 9. So they called 4. Almost half of their witnesses they wanted transcripts for. And they had the 2 FBI agents. They had Amanda Young and they had Richardson. I believe that was his name, or Richards. And then they had Espinoza, and then they had Dr. Loftus. Now, remember, Dr. Loftus was the expert witness that the defense called. But notice that they didn't want the transcripts of Dr. Lisa Rocchio. No expert witness transcripts were warranted. So why would they call the defense expert, but not, or I'm sorry, when I say called, they're requesting to reread the transcripts, but not the prosecution. Interesting. So this was the scene from when Visosky testified. Visosky gave us a lot of details about a lot of this. I was going to go through this in more detail. Don't think that we need to do that now because we sort of know what the jurors are thinking. And so the rest of this was just basically a recap. And so I think it's now a good time to take a look at the questions from our friends at watchingthewatchers.locals.com. And I've seen a couple super chats come in as well. We've got Faticus is here. Good to see you, Faticus. Says, how does this affect the Prince Andrew lawsuit? So I don't think that it does really, right? That's a civil case, and Maxwell is not a party to that case at all. I think that it is a moral boost certainly, that this organization, this disgusting scheme of people can, be cracked to some degree. And so, I'll be curious to see where that goes. Now, that case is scheduled for a whole slew of activity early next year. I think a bunch of stuff is going to be, we've got status conferences. A lot of the stuff is going to be broadcast, although you can't record it or rebroadcast it, but it's going to be a little bit more accessible, and it's a civil case, so it's a little bit different standard. So it's a great question, Faticus. I don't think it's going to. Virginia Giuffre is going to have that case and would have had that case regardless of what happened here, because it's a separate party, right? She's going directly against Prince Andrew, and she has different claims than what Maxwell had. So he's not, to my knowledge, he's not part of a conspiracy claim or anything like that. So it is a little bit separate. I think she's charging him with or suing him for battery and for intentional infliction of emotional distress, which sort of are separate issues. Not real. I mean, they're related, but they are separate, I think, criminally speaking. So it's a great question. Nate Kidwell says, fantastic chats and discussion. Really enjoyed having your insights throughout. Even thought it was obvious. Great seeing you break down the steps, even though it was obvious. Great seeing you break down the steps. Well, thanks, Nate. Yeah, I mean, we went through this one from beginning to end. We invested a lot of time on this case. And, it's an outcome that I think a lot of people are happy with. And I'm happy to see that there is a chip in the facade. I like to see when the people who are part of a different power structure, who typically have operated under a different set of rules, and she did, Ghislaine Maxwell and this whole organization, right? They ran around like kids in a candy store doing whatever they wanted for the last 30 years or so. So to see that happen is, of course, very good news. But it's bittersweet to me for a little reason, and that's because I think what's going to happen here is the government is just going to call it, oh, we got it done. Oh, well done, everybody. Good job there, Allison Moe and Maureen Comey. Well done. Let's go have a cocktail, shall we? Perfect. And all of the Epstein stuff is going to be done. All the Ghislaine, it's all just done. We're just done with it. And the real people who were orchestrating and funding this and sort of making it all happen and using the services aren't going to be brought to justice. And that's what sort of irritates me about this. They're just going to wrap this up, put a nice bow on it, and we're done. Move on to the next case. And so that's, of course, not something that I want to see, although I am happy that there is a resolution here that went the way that it did. Not Applicable says, man, you're a great law teacher. Keep it up, Rob. Well, thank you, Not Applicable. I appreciate that. And those were from YouTube. So let's check over at watchingthewatchers.locals.com, and we'll check in with the forum as well, the poll form, and see what the poll form says. We got the Maxwell sentence poll form saying that we've got 20 plus 38% say 20 plus years. We've got 5 to 10 years, say 20%. This is pretty evenly split. Biggest appealable issue, non-prosecution agreement, is in the lead with 30%. COVID, urgency, rushing a verdict looks like 26%. 16% say jury instructions, and it could be something else. 83% say nobody else is going to be prosecuted. This is it. And 65% now are saying happy with the verdict. 21% still undecided. And so I think that's fair. I think that there's going to be a lot more to come on this. We got some questions over from watchingthewatchers.locals.com. Vienticus Prime says, see, I was right. All you had to do was deny them Hot Pockets. That's it. Once they didn't have any Hot Pockets, they got that hanger, and they were very hangry. Vienticus also says, your practice must do well. Those business cards are fancy. Well, we like to class things up around here. They are pretty nice. They've got this nice little, come on, there you go. They've got this nice little, kind of, what is that? It's like a foil type of thing. It's pretty fancy. Thank you for that, Vienticus. I'm proud of him. We have another one here from Sergeant Bob says, I did earlier opine that all the requests for more info was because they were trying hard to make that leap to beyond reasonable doubt. Juries as reps of the general public do not have any use for people like Ghislaine or those that enable. They were trying hard to make that leap. Trying, grasping, doing their civic duty. They wanted to find a reason to let her go and adhere to that presumption of innocence. And they read and they read and they highlighted and they highlighted and they stickied it up. but they couldn't come to the conclusion. And yeah, I think you're right, Sergeant Bob. Nobody's got any use for those types of people. No question about it. Molly says, thank you. Should we expect the piggy the squeal? Molly says, thank you. Should we expect the piggy the squeal? The piggy maybe to squeal? Oh, I see what you're saying there, Molly. In other words, Ghislaine Maxwell, is she going to start singing like a canary? I don't know. I don't know. We're going to continue to pay attention to that. That's for sure. Now, the other question, of course, why don't we poll form that? We can add some interesting poll questions on this. Now, do we want to ask the Epstein question? Should we ask that question? Yeah, maybe we should. All right. So, how do I change this here? Ghislaine Maxwell. We're going to add one more question here. How about Ghislaine Maxwell? Is she going to turn on anybody else? So we'll say implicate others, remain silent, or how about we'll call it silenced. How about voluntarily silent? We'll call it voluntarily silent and involuntarily silent. All right. And so we have a new poll now that's on the form. Is Ghislaine Maxwell, now that she's going to be remanded to custody for the foreseeable future, is she likely to A, implicate others, B, voluntarily remain silent, or C, be involuntarily silenced, a la Jeffrey Epstein? Let's see here. Involuntarily silenced. Let's take a look at this response and do a summary on this one. All right, here we got it. Ghislaine Maxwell, will she implicate others? 20% say she's going to implicate others. We've got 6% say remain silent. 9% say, no, not that many responses yet. So 61% are saying involuntarily silent. So I think we can see how this one's going to go. All right. And so let's see what else we've got over from Watching the Watchers. Good question, Molly. Good question on that one. Let's see what else we've got. DG McBride says, as ironic as this sounds, Maxwell stands a much better chance on appeal than she did at trial. The application of the circa 2008 plea agreement to include Maxwell is a question of law which the jury as a fact finder could not touch. This is one of those unusual cases where an appeal is a better shot for a defendant than the trial itself. Totally agree with you on that, DG McBride. In fact, let's pause for a moment and explore that issue, shall we? So if we go over to the mind map, which is available down in the description below, you're going to see there are some people poking around up there. Shout outs to everybody who's in the house. Musically Kid is checking out along with a number of guests over there. And so let's revisit this. So we've got the Ghislaine Maxwell mind map, and we'll pull that up there on the screen. And the reason that DG McBride was talking about this as a very, very big potential issue that I think that her defense team is going to sink in on is over here. Remember that in the Jeffrey Epstein wing of the mind map, we have a lot of activity going on over here. In particular, we have this entire non-prosecution agreement. So let's close this up. We'll sort of close up some of the unindicted, unnamed co-conspirators, people tossing, number of names around in there, but they are all unnamed. We don't know who they are, but there was a non-prosecution agreement that came back out from Jeffrey Epstein. And this was back in, let me take a quick look at this one, pull this actual document up. Yes. Okay. So here this is. Let me see if I can zoom in on this puppy a little bit. So this is the Jeffrey Epstein non-prosecution agreement. This was filed. This looks like the Florida docket back in 2016. Place in a file. Now, folks, this is something that is fairly common. Okay, non-prosecution agreements are a common thing. Happens regularly. It'll say something like, okay, look, we know that you were charged with a domestic violence offense. We're going to enter this non-prosecution agreement. We won't prosecute you. It's your first defense. If you got into an altercation, fine. As long as you go and you complete some counseling and get some domestic violence therapy and you never do it, blah, blah, blah. then we won't prosecute you. And we're going to fill out this non-prosecution agreement. You do this, we won't prosecute you. It's a prosecutor's office policy. You get your first one, an opportunity to work it away. Common. This is not common. What we're seeing here is absolutely uncommon. In fact, I've never seen anything like it before. Because what we have here is a non-prosecution agreement that doesn't just bind Jeffrey Epstein, but it binds all of a number of co-conspirators that are named in this document and also other unnamed co-conspirators. So like James Bond has a license to kill kind of a thing. This is like a license to commit crimes and not be implicated, because this non-prosecution agreement is so big and overbroad that the umbrella covers virtually everybody. So this is a strange thing that happened. And so this non-prosecution agreement was entered in the investigation of Epstein, and he had some of the best lawyers in the country, arguably the world. The investigation concluded in around 2007. All of this background from 2001 to around 2007. This is page 7. Now they're saying Epstein seeks to resolve this globally. And so he's going to do certain things in order to get the benefits of this agreement. And we're going to do certain things. Why the government agreed to this, I have no idea. I don't know what type of leverage that Epstein had over the U.S. government to get such a blanket type of non-prosecution agreement like this. It's nuts. But here are the terms. Epstein's going to plead guilty. He actually has to plead guilty to the charges. 30-month sentence, 6 months jail, 12 months, 6 months in jail for all charges. And he basically, this is like a I think he went and spent the day there and then went back home, work release, all sorts of stuff. Epstein's attorneys are going to provide a list of all the victims. He's going to create the Epstein Victims Compensation Fund, right? All of these things come out of here. Now, Epstein understands that the U.S. attorney has no requirement to make the states comply with any of this stuff. Epstein's aware that he's, waiving his rights and things like that. This is signed off on by Epstein. We also have A. Marie Villafena and R. Alexander Costa. Now, there's a section in here that we skipped over, but it's right here. This is so the government just told us what they want out of Epstein, right? They gave us this. They said that Epstein is, going to serve time in jail. He's going to identify the victims. He's going to waive his rights. He's going to, resolve all of these things. And Epstein's going to do that, right? He's going to suffer. He's going to be penalized. So what is his reason for entering into this agreement? Doesn't he want something? He wants to get something out of this, right? Otherwise, why would he enter into it? Well, he's getting a pretty good deal. Here is what, for some reason, he got. In consideration of Epstein's agreement to plead guilty and to provide compensation through the Epstein Victims Compensation Fund as described above, if he successfully fulfills all terms of his agreement, U.S. says no criminal charges against any potential co-conspirators of Epstein. Look at this line. Including, but not limited to, Sarah Kellen. So my question is, if Ghislaine Maxwell was a co-conspirator and she just got prosecuted and convicted, why is Sarah Kellen not getting it? Okay, because she's in this as a co-conspirator of Epstein. Why did she get written off? Why did Adriana Ross, why did Leslie Groff, why did Nadia Marcinkova not get prosecuted? And why is Ghislaine Maxwell not considered this a potential co-conspirator of Epstein? Any potential co-conspirator. Maxwell charges came after this 2007 plea deal. I think she's included in this plea deal. I think that she is included. I think that this covers her. I think that she is any potential co-conspirator of Epstein. She just got convicted for conspiring with Epstein. So I think she's protected by this thing. And the judge decided that she wasn't. This is a problem in the law. I think the case should have been dismissed, right? Because you can make the same argument. Where are the criminal charges for Adriana Ross? Where are the charges for Leslie Groff? Where are the charges for Nadia Marcinkova? They're nowhere to be found. Why is that? Well, and it's these women right here. They're all here. Nadia Marcinkova, 35, allegedly had encounters with underage girls. She was also an on and off girlfriend of Epstein's. sounds basically exactly like what Maxwell was doing. Why is she not being prosecuted? Well, she's protected by this agreement. I would argue so is Maxwell. And I'm not saying that to support, please don't misinterpret this as like, oh, well, Maxwell should just walk free. My bigger issue with this whole underlying case is, why was this agreement even concocted in the first place? Why was that allowed? And why is it being, why is Maxwell just sort of being the sacrificial lamb on this thing? These women were involved. They're in a government document. They signed off on it. Leslie Groff, 53, was reportedly Epstein's executive assistant for 20 years. Not going to hear from her. Adriana Ross, she was in her 30s, also an ex-model who allegedly helped organize massages for Epstein. We didn't hear from her in this trial. Why not? Sarah Kellen, same conversation, 40 now. Also allegedly had a Rolodex of women she called to give massages at Epstein's home in Palm Beach, Florida. She flew hundreds of times on Epstein's private jet, the Lolita Express. She was an actual recruiter. And that's why she apparently is also a horrible neighbor too. Over from the New York Post. Recruiter and a horrible, she's a quote, a sex slave recruiter. But she got written out. She's protected. Saying she was a victim, not a monster. So why is this woman, Epstein walking with Sarah Kellen, she is immune from this whole thing? But not Ghislaine Maxwell. Because they all fall under the agreement. But Maxwell doesn't, as a potential co-conspirator. Not so sure about that. All right, let's see what else you've got to say over at, that's a great question. Thanks for the opportunity to dive into that, DG McBride. Paralaw says, Maxwell and Epstein were poised to live a life most people would not even imagine. There was so much they could have done with their lives, so many people they could have helped while living life free of want. Yet one died in prison. The other may very well do the same, of old age, of course. Just a shameful waste of life. It is. They say that sometimes people just get commandeered or overtaken by evil or depravity, or something happens, something overtakes a person. And it is tragic. It is sad when that happens. It happens all the time. It happens a lot with addictions. It happens a lot with people just losing. People just lose, and they lose themselves to an evil side of life, and it's a sad thing. And it's cascading, right? Consequences ripple throughout the world in a very horrendous way. Leafy Bug says, I'm not happy with the outcome, only because I think the trial should have been much broader and there should have been a lot more people on trial. Ghastly Ghislaine is far from the only guilty party here. She's probably not even a major player, but everything is being dumped on her. Doesn't look like justice to me. Yeah, I'm not a fan of that, Leafy Bug. I'm not either. Ghislaine Maxwell's a monster. No question about that. What these people were doing was heinous and horrendous. But she is not the sole proprietor of this organization. She's not the queen bee of this thing. Many other people were involved, and I have a sneaking suspicion it involves some very powerful people, maybe even people deeply rooted in the U.S. government. And so for them to just, oh, we're done. Oh, no, it's done. We're done. We're done. Good job, Maureen Comey. Good job, Allison Moe. Good job. Well done. But there's a lot more work to do. I mean, if you're interested in that, or is this just the end of it? It's just the end of it, which is not good. Let's see. Vienticus Prime says, I found a picture of how bad the presence of Omicron was in the courtroom. Let me see. This is a very interesting link that you sent over here. What is this one? I am Lure. Who is this? I am Lure, ruler of the planet Omicron per se. Is that from Futurama? It looks like a Futurama drawing, but I didn't watch that show, so I don't get it. So I apologize for that, Vienticus. But I'm sure it's hilarious. And I'm sure other people get it. And I'm sure they're laughing hysterically. Thank you for sharing it. Sergeant Bob says, being held during Christmas would be one thing. I do not think most jurors would think New Year's would be that big of a deal. Maybe I've just seen too many New Year's Eves, usually while working. Well, I'm with you, Sergeant Bob. I'd be more irritated that I'm not in bed by 10 o'clock, but they are in New York. So maybe they go down to that, Times Square and they turn it into a big thing. I'm not sure. But yeah, about 10 o'clock, it's midnight on the East Coast. Sergeant Bob says, Everdell's pretty sharp, but I bet he is not cheap. Good analysis by you. Thank you, Sergeant Bob. And Sergeant Bob, by the way, if you're not a member over at watchingthewatchers.locals.com, Sergeant Bob sent an amazing email yesterday that was a conversation about the story we talked about yesterday, the Burlington Coat officer-involved shooting. And so very good feedback. He sent an email with a diagram that was by Miss Lucky. And so we had a good conversation about that earlier this morning at watchingthewatchers.locals.com. And we may talk about that when that case comes back up in the queue. We put together a queue. Oh, you want to see the queue? Do I have this pulled open here? Yeah, so also at watchingthewatchers.locals.com, we were putting together a case list, sort of the docket that we're going to be covering for the new year. Let me show you what we've got here while we've got this open. We've got Julian Assange, Garrett Rolfe, Rayshard Brooks, Ryan Remington. I'm not going to read through the whole list. You can sort of see them here. Of course, Alec Baldwin, Kyle Carruth, the Crumbleys, Daryl Brooks, the Whitmer plot, Steve Bannon, Ghislaine Maxwell were here. Now, she is in trial, but now we're going to be scheduled for sentencing. And so we're going to have to find out when that sentencing date is. Kim Potter, Durham investigation, SCOTUS mandates. We've got Dominic Black in the Rittenhouse case. We've got Daybell case. We've got a lot of stuff coming up in 2021, but Sergeant Bob is a very, very awesome part of our community. We're grateful for you. We have your stalker says, Rob, your heads up, just your Rumble stream doesn't seem to be working. I forgot to mention that. Thanks for bringing that to my attention. It is not working. So I use Restream to syndicate the show across a couple different places. I submitted a support ticket to them today, and they're aware of the problem. They know that it's not working for custom RTMPs. They said that a fix is right around the corner, so hopefully we're back up over there on Rumble tomorrow. Thunder7 says, Maxwell will now name names. If she's given a 5+ year sentence, no way she's going to do hard time while the perps go free. We all know about Prince Andrew, Clinton, Gates, and the others, but not from the madam's lips. What a story she has to tell, unless the intelligence agencies get to her before she spills the beans. That's from Thunder7. Which is a good reminder to check back in on the voluntarily or the involuntarily silent question. And it's 76% say she'll be involuntarily silent. Whatever that means. I don't know what that means. I don't know. Look at this little green sliver here. We've got one person says she's just going to remain silent. Well, what is this one? Why did I put that there? No, we can get rid of that. We can get rid of that question. That's a mistake. That shouldn't be there. All right. So we got a few more questions from our friends at watchingthewatchers.locals.com. English Dave says, you asked for our opinion, but what's yours? Do you think this is the right decision? If so, what sentence do you think she should get? What sentence do you think she will get? So, it's a good question. I don't know what sentence she is going to get, and it's hard. Listen, generally, folks, I'm always going to default to there's reasonable doubt in every case. So I think that, I think there was a lot of reasonable doubt in this case. And I genuinely mean that. I really think that there was. I'm not sure that this is the right legal decision, but it sort of feels like the right moral decision. And so it's a complicated position to be in. And I say that with all due respect to the prosecutors out there and everybody who's jumping for joy on this case. But this government case, this prosecutorial case, from a defense attorney perspective, okay, even if you're happy with this outcome, let's talk about the mechanics of this case. This case was garbage, okay? They presented 4 victims, 2 of which were we got instructions that they're not really even victims. Multiple of the victims were sort of terrible witnesses. We had Jane, who said, I don't recall, a number of different times. We had Carolyn, who was, a former recovered drug, not even a recovered drug addict, I think like an actual active drug addict. And so, not that there's anything wrong with that. I, have a lot of people in that space. I know a lot of people that have been in that world and recovered well. But the point here is you're talking about credibility. You're talking about reliability. You're talking about memory. And the government's case here, they took 8 days and they arrested. They know they had a terrible case. It was a garbage case. The case is 20 years old. There's plenty of reasonable doubt. I think legally, Not a good outcome based on what I have seen presented in court. But the right moral thing to happen, right? She's a monster. She's been a monster for a long time. I'm a defense attorney, so I'm always going to hold the line on the reasonable doubt standard. I think it's a very high standard. And so I would argue that there's a lot here that I could latch onto and find reasonable doubt about. But that being said, right, the reason why it's sort of a bittersweet verdict, I think morally it's the right thing to do. I don't want people like this running around. I don't like people who are part of the oligarchy operating according to a different set of rules. And when I talk about criminal law and justice, these are the types of cases that I support being prosecuted, right? People who are operating as though the rules don't apply to them, rather than the high schooler who got popped with weed in his car on the way home from high school, right? These are different tiers. And so when I see an outcome like this for somebody who's in a different category, I can say, yeah, morally, that feels like it's the right outcome, certainly. But legally, it's hard for me to do. I think the case was very weak. I think the prosecutors knew it was very weak. They rested after 8 days. 8 days in this case. That's embarrassing. All right. And they know it. And so the jurors found, they saw through the smoke screen of a multi-million-dollar defense, but she's also got a lot of leverage. And you also have to think about this from a sentencing perspective. The judge is going to hear this also. And the judge, I'm not sure what the judge is going to do in terms of sentencing. A lot of the testimony, a lot of the allegations about what Ghislaine Maxwell did in this case were about holding hands and touching breasts, right? Twin torpedoes and things like that. Epstein, a lot of the testimony was about what Epstein did, not a lot about what Maxwell did. And so when you're talking about sentencing now, right, the judge has to take that into consideration. You can't punish Ghislaine Maxwell for what Jeffrey Epstein did to the women. And what did Maxwell do? Well, we don't know. Jeremy Matrita says, Rob, what type of battery do you think it'll be? LiPo or NIMH? That will definitely help what type of charges are used. Sorry, couldn't help myself. Jeremy, that's a Virginia Giuffre joke. She's filing criminal charges, not chargers for battery. Battery is a physical touch that happens in an offensive manner. We have another one from Tweak, says, Rob, an update on the sleazy Andrew and Giuffre civil lawsuit. Epstein's settlement with Giuffre to be made public affects the Prince Andrew case. Yeah, this is coming out. It says a 2009 settlement agreement between the late financier, Epstein, Virginia Giuffre. Those will be made public next week, January 3rd. Yeah. Saying, okay, here's from Tweak. He says, it will be interesting to see what other names might be included in the settlement. Not very optimistic, but I'm still not entirely sure that this whole Epstein saga is over yet. I hope not, right? And I really hope not. I think that there's a lot of problematic things that happened here, and the tentacles go far and wide. And we certainly want to see that those people are brought to justice. We have another one from Sergeant Bob, says she will roll over if gains a reduced sentence. If she gains a reduced sentence. I see. So Sergeant Bob is saying, yeah, if they give her a deal, she'll talk. Otherwise, no. Madam Ghislaine says, I'm getting a tat from my cellmate tonight like McAfee. Not suicidal. I saw another story, another blurb that maybe somebody from ABC News was actually there at the courthouse, potentially interviewing her. We'll see. Kincaid says, hey, Rob, I agree. I think the agreement will in the end clear her. Don't want to annoy you, so I will keep it short. I would like a guess on when you think she will be freed, LOL. That agreement is simply insane. It is insane. I don't know. So I think it would. So here, my take on this, kind of from the beginning, has been that she gets convicted, but then she wins on an appeal, just the same way that Cosby did. Cosby was convicted, went up on an appeal. Cosby's a free man, and most of the country didn't even know that happened. What? I thought he was convicted. Didn't he go to prison? Yep. But then not. Same type of thing. Now, there's been some pushback on that. I think News Now Wyoming, I'm not sure if he's here, but he said that it's a little bit different because in that case, there was consideration in legal terms. In the Cosby case, what he did is he actually did something in exchange for that protection. Cosby said, I'm going to sit down, I'm going to give a deposition. In exchange for this deposition, I want protection from anything I say during the deposition. He said some things that incriminated him. The government prosecuted him using his own statements. He got convicted. Government should never have done that. They gave him immunity, so they couldn't have prosecuted him. News Now has said, and he's on YouTube, News Now Wyoming says that that is the consideration that distinguishes this from the Ghislaine Maxwell case. That Ghislaine didn't do anything in order to earn that protection. And so my question, of course, which is, I think it's a valid point, but my question, of course, would be, did any of the other co-conspirators? And nobody else has been charged. Why is Maxwell? Unless we know that the named co-conspirators in that document, like Nadia and Leslie, did they give the government something in order to get that benefit? I don't know. Kincaid says, yeah, that agreement's insane. We have another one says, no question. Can the prosecution offer a sentence reduction for other suspects? How might that likely play out? Thanks, you're the best. Yeah, that's a good question. So certainly, right, the prosecution is going to make a recommendation for sentencing. And if they have anything that might sway them or anything that they want in order to negotiate for a better reduced recommendation, that would be a conversation worth having right now. A lot of the time, these conversations happen before the trial takes place, but you can do, in law, it's called a free talk. It's a thing, right? You bring a defendant in, this person knows a bunch of stuff, you negotiate a deal with the opposing side, the detective, the investigator in the case, and you say, listen, we've got some data, you want the data, we want to make sure that this person doesn't get, hurt as a result of giving you this data. What do you have to offer us? If you can work out a deal, you have a free talk. Tell them everything, go for it. And then that happens. So, it's something that is not applicable in a lot of cases, but in some cases it is. The government wants something badly, and if you have that is leverage that you can use in your case. Grouchy Old Cat Lady says, I agree with you 100%. Maxwell was definitely covered under the agreement. Yeah. So even though it's like a moral victory, it's like, yeah, okay, fine, she got convicted, but I'm not sure that it's over. Leafy Bug says, I think Maxwell would have already implicated others if doing so would have been any benefit to her. I don't see how she could blackmail her way out of her predicament at this point. If she has verifiable dirt on big names, it seems to me that she has an incentive to not go public with this, as it could still be used as a deterrent to her being Epsteined in prison. If she puts what she knows into the public domain, it no longer has any value for her. That's from Leafy Bug. That's true, right? That is true. It's leverage. And so if she gives up that data without getting something in exchange for it, she loses that leverage. So why would she do that? It's a good point. I don't think that she would. And we have a few more. We've got Aussie Lawyer says, thank you from an Aussie Lawyer. Says, I followed your coverage of this every day today. I got the best birthday present ever. Guilty, plus your coverage. Happy birthday, Aussie Lawyer. Well, that's a nice Christmas present. And you know who's unhappy with her belated birthday present? Ghislaine Maxwell. Yeah, her birthday was the same day as the day we celebrate the birth of our Lord and Savior, Jesus Christ. And her birthday present was delayed. Amazon delivery was backed up a little bit, and she got a big fat guilty verdict, 5 of them on her lap today. And Aussie Lawyer, you're celebrating as well. So it's just birthday season. Cheer is in the air. Happy birthday. Thanks for being here and for writing in from the land down under. We've got another one from the Aussie Lawyer. Says, like you, I'm frustrated by the brevity of the prosecution's case. However, the strategy of running a case can often involve being succinct with the strongest evidence and the charges only or available. Yeah, there is truth to that, right? And I think that as a prosecutor, you can risk going too long. I mean, look what happened in the Kyle Rittenhouse, Thomas Binger, James Krause. I mean, it was the most droning, boring prosecution that you could see. And it didn't work out well for them. I mean, they got sort of nationally lambasted for their performance in that case. And there's truth to that. You know, if you continue to beat a dead horse, if it takes you 6 weeks to say what you could say in 2, say it in 2. Right? Brevity is the soul of wit. Consolidate that thing. Now, I don't think that's what they were doing here. I think that their case was bad. They sort of treated this like a throwaway case, and they took 8 days, and nobody else is being prosecuted, and that's the end of it. Feisty Lady says, have you seen the court order signed today? to make public the settlement agreement with Prince Andrew. Here's a link to the document. I feel like we covered this before, but I didn't know there was a new document. Yeah, it's a new document filed today, and I didn't see this one. Wow. Okay, so no, I have not seen this. We covered something about this, but this is brand new. Let's look. A document entitled As Settlement has been released, said to have been executed by the plaintiff and by the late Epstein. Same document been filed in another case. In light of sealing order in the first action, it's been filed under seal. On December 14th, we ordered that in the absence of showing honor before December 22nd, that this was going to be public on July 3rd. No showing has been made. Okay, so that's what this is. Yeah. Okay, yes. Awesome. So we did talk about this. That's right. And they said that they wanted them to respond as to why it should not be unsealed. Court said, we're going to be unsealing this thing unless you tell us why we shouldn't. Nobody responded, so they're just affirming it. Accordingly, on or about January 3rd, it's unsealed. Oh, perfect. Specifically, the court shall unseal and place on the public court docket. Oh, that's just great news. That's going to be fun. So we'll see what's in there. This is a signed settlement agreement executed by Virginia Giuffre and Jeffrey Epstein. It's a settlement agreement. We'll see what's in there. We'll see how much of this is redacted or not, but thank you for bringing that to my attention. So that came in from Feisty Lady. Thank you for that, Feisty Lady. Very, very cool. Okay, what else do we have? A couple more. We've got Suspicious Chick is here, says, I feel like that she is the, quote, sacrificial lamb and absolutely no other big names were dropped. I honestly think Judge Nathan fumbled the case on purpose. She's going to win her appeal and walk free. This was too easy. That's from Suspicious Chick. Yeah, I think you're onto something there. And I think you have a right to be suspicious. Leafy Bug also says, slightly off-topic question. I watched the latest season of Narcos Mexico. The DEA agent infiltrated a 12-step group undercover posing as a recovering addict. He would form relationships with recovering addicts who were traffickers, win their trust over time, and bust them when they offered him a smuggling job. Have you ever heard of this kind of thing happening? Law enforcement infiltrating these kinds of recovery programs? I have not heard of that. You know, that type of stuff would be very looked down upon, sort of depending on, that would be an extremely bad form, you know, to sort of go in there and try to manipulate people who are in the throes of their addiction and trying to recover. I think that would be looked at with very, very bad form. I mean, many law enforcement agencies or judges, you know, they sort of refer people to these programs because they are so powerful. But if a law enforcement officer was doing something like that, you know, I don't think that anybody would look kindly on that. It would sort of be like, it's a sacred thing. It'd be like trying to use your pastor or starting a church so that you could exploit people, right? That's a religious relationship, or like a counseling relationship, or like a therapist patient relationship, lawyer. It's sort of like that. And it's sort of viewed with that same type of reverence. And so law enforcement stepping all over that would not be looked kindly upon by the legal system. We have Kincaid says, I do not think that Maxwell needs to the language. I do not think Maxwell reads like the language could easily include her. Like you said, someone just wanted to lay low for a minute, which means the dirty deeds will all be going on. Yeah, so they'll wrap it up. They'll set it aside, and then we'll see where it goes. We've got English Dave says, it Aussie like Aussie, not Aussie. So say Aussie. Aussie like Aussie, not Aussie. Aussie. Aussie with Z's. Thank you for correcting me. I'm just a dumb Arizona boy. I don't know any of this stuff. Aussie. Thank you. All right. Foil-hatted Tin Man says, did anyone see Epstein's dead body? Not trying to be too macabre, but too easy to make him see someone else's new identity. Foil-hatted Tin Man. Yeah, he got kind of carted out of there on a gurney, and we didn't see too much of him, did we? Very interesting. Vientica says, it's funny how the feds infiltrate rings of non-existent terrorist groups, but get nowhere near the sex trafficking rings. By the way, you didn't get my package yet. I don't think so. I don't think so, Vienticus. Did you send me something? No, I don't think so. But it does remind me, I did get a package from Beyond Reasonable Doubt. Sorry, Vienticus, I didn't get yours, but I put this one here. This is from Beyond Reasonable Doubt. It says, celebrate your reach. Each show makes a bad time better. That is from Beyond Reasonable Doubt on watchingthewatchers.locals.com. And it was a very beautiful succulent that was delivered to my office. It came before Christmas, and I apologize for saying thank you for that. But I absolutely love it. It's out there on my desk. And so I wanted to say thank you for sending that in. But Vientikis, no, I didn't get anything from you. I don't think so. Aussie Lawyer says, thanks, English Days. It's definitely Aussie, but Aussie is cute. All right, well, I'm going to correct it. It's Aussie. Aussie Lawyer. Sorry, I didn't know. And I think we have one more before we wrap it up for the day. Kincaid says, sorry for the typo. Speaking of religion, did you hear Facebook is making deals with some for their metaverse? No. Facebook is making deals with religions for their metaverse? Oh, no, I did not see that. And that, my friends, is it for the day. I think that's all that we've got to talk about Ghislaine Maxwell. For the foreseeable future, there will be some more documents and new stuff is going to continue to come out as the sentencing date gets scheduled and as more of these exhibits roll out. And so before we wrap up for the day, I want to welcome some new people to our community. Big shout outs to Gotcha Good, signed up at watchingthewatchers.locals.com. We've got Jim 2008, Falcone, USNY. Yeah, well is here. Reen, not RWC, Chuck David, Mark on W, Shindog, Nosy, Texas Rosie, Taz Mom, Cookie Monster 2, AJ Darsha. We've got Molly Pop Inc., Guitar Terry, Randy J, Westworld, Equestrian Girl, Richie DC, Red Jersey, Nikki Dragon, Things and Stuff, Donna 107, The Vez. We've got Jimmy W, Big Brother Bites, Kimmy Cat 03, Kevin AZ, Antar 24, Queen of Tennessee, Rebby Lee, Music Box Lady, and Big Rear in the house over at watchingthewatchers.locals.com. And there's other people chatting away over there. We've got Gecko Man, we've got Feisty Lady, Dave 2, Jumpin' Jeff, Radices over there, Tweak, Paralaw, Miss Lucky, Molly Pop, Phil and Flyover, No One You Know, Moose in the house. What's up, Jeremy? Kincaid, chairman of the boards there. Vientikis Prime, Suspicious Chick, B-Spec, Black Cat, Meow, and many others at watchingthewatchers.locals.com. And that, my friends, is it for me for the day. We're going to be back here to do it all again tomorrow. And I hope you join us 4 p.m. Arizona time, 5 p.m. Central, 6 p.m. on the East Coast. And for that one Florida man, everybody else have a tremendous evening. Sleep very well. See you right back here tomorrow. Bye-bye.